The worst experience I had as a tenant, it was when I was unable to pay a rent for a year. Each time my wife cook any delicious food or that, the landlord will get angry and say, you didn't pay. And because I love all this chicken, all this head of goat as a person. So it's always a problem. It's always a problem.
Yeah, just like every other contractual relationship, just like when someone comes and borrows money from you and says, oh, please, Ola, borrow me 10K. See, this 10K, give me 1 week, I'll pay you back. Just please, yeah, I'm so, everything is just so bad for me and all that. I need it now, and I'm expecting money. And the next 1 week, I'll pay you back. And 1 week goes, you don't hear from the person. The second week, nothing. The third week, nothing. And before you know it, you're trying to claim your money, and the next person starts saying, is it because of 10,000? Why is 10,000? Why is it so because of 10,000? So that's the same way it is in tenancy relationship.
My tenant will always be in exchange of words. For them to pay, to renew their yearly tenancy has always been a problem.
The tenant took me to court. He defaulted in his payment by way of his rent had already expired. That's the truth. And we gave him grace of about 2 months plus. Then at the end of the day, he wasn't still willing. Then there was an extension of another month until I had to call my lawyer. Please take up this matter. Then we gave him quick notice. Actually, he wasn't the one staying there. It was his third wife. He's polygamous in nature, so his third wife is the one that stays in the property.
Because when you want to rent your house to someone, the mandatory thing first and foremost is that the person must feel like when you go to bank, what they call know your customer. So you must supply information with respect to know your tenant. Now, in that information, you have to know who is paying the rent, because your contract, your tenancy contract, is between you, the landlord, and the person who is making the payment, regardless of who is staying there. I don't know if you understand me. So, in this instance now, if it's the husband that is paying the rent, that means every relationship between the landlord and whoever is there is the husband who is paying the rent. So if he's serving notices, for instance, yes, he's serving notices to the husband. So more or less, the wife is like someone who is an occupier. You understand? Or someone can even refer to maybe as a tenant at will. You understand? But your relationship apparently is with the man who is paying the rent. You understand? So if you're going to proceed against anybody in court or for any reason or serve notices, is apparently going to be addressed to the man and is going to be served on the man. Now, if the man is not there, you cannot trace him, then you can now do what we call, ask the court for what we call a substituted service to now serve maybe some other person in that same property that is staying. So in that instance, you can serve the wife or you can paste on his door and all that. But the proper person to proceed against is the man that he rented the property from. You understand? If the man is the one that he had a contractual relationship with. But if it is the woman that came and supplied the information and possibly even paid through her account, but it is the husband that gave her the money, then your relationship is with the woman.
Whenever the tenancy expires, they give us like the tenant, they give us like just 1 week or 2 weeks or highest 1 month. Then if you don't evacuate or if you don't reimburse them your tenancy, they'll throw away your this thing. And we have very little judicial protection in terms of trying to let the authorities know that this is what we are facing here.
To move out of my place or his house when I'm not ready to. His sons is coming back from the US, stuff like that, so he has to give him the place. So I was supposed to move out for the sons to take over the place, even when my rent is not yet due for me to go out of the place.
In law, there are 2 different types of quit notice. Now, these 2 different types of quit notice are actually statutory. Now, where a landlord wants a tenant to leave the premises or vacate the premises at the expiration of his tenancy, then he issues the tenant the requisite notice. Now, for instance, if your tenancy agreement says 3 months notice, you issue the tenant a 3 months notice. If it says 6 months notice, you should tenant a 6 months notice. If there's no agreement at all, then look at what does the law say. The law will tell you if it's a 1 month tenant, you issue 1 month notice. If it's a 3 months tenant, you issue 3 months notice. If it's a 6 months tenant, you issue 6 months notice. If it's a yearly tenant, you issue 6 months notice. That's what the law says. Now, there's something very important about this notice that I must specify. Most people think that when you say quit notice, when it says 3 months quit notice, it starts to count from when their tenancy has expired. No, notice is actually issued before your tenancy is expired. So where your quit notice, where your notice period is 3 months. So it means that 3 months back before your tenancy expires to up to the eve of the expiration of your tenancy, that's what is counted as 3 months. So when that notice is given, it has been, if an effective notice has been given for you to evict the property at the end of your tenancy. Now, where that tenancy has expired and you still remain in custody of the place, you have not left. Now, before the landlord can evict you, he now has to issue what we call 7 days notice of owner's intention to apply to recover possession. Those are 2 statutory notices. So when he issues you that 7 days and still you don't leave, then he will proceed to court to recover possession. But now there's a new procedure to that. There are actually 2 cases by the Supreme Court which have changed the dynamics of tenancy and tenancy relationship. One is the case of Odutola versus paper sack, which was decided by the Supreme Court. Now, what Odutola versus paper sack says is that where your tenancy is due and you have not paid, what you are entitled to is just that 7 days notice. So the landlord is not bound to issue you any other notice before then. I don't know if you understand me, because the landlord does not want you to leave. He actually expects that when your tenancy has expired, you're going to repay him. You're going to pay him his tenancy. That's what he's expecting. So at the end of your tenancy, what he's expecting is a credit in his account. And for some reason, you have not credited his account and your tenancy has expired. If he wants to evict you, what you're only entitled to is that 7 days notice of owner's intention to recover possession, because your tenancy is due.
As a landlord, I have some properties, and I've seen that most of the tenants, after the yearly payment, they won't want to pay because they feel that the court will be maybe a platform for them to use, to sustain them, to keep them in the house. But we quite know that the policies that talks about tenancy agreement is not complete, it's not spelled out. It's not spelled out completely for people to see. So as a result, people feel that as a tenant, they can do whatever they want to do to a landlord, since the court is there as a defense, as a backup for them.
If you don't want to get into that flexibility, that means you have paid for your rent. Possibly your landlord has acknowledged receipt or have evidence of that payment, and you're in occupation. That means if anything happens tomorrow, respect of that tenancy, what we will resort to as lawyers is what is contained in the Landlords and Tenants law or act, as the case may be. So the implication is that that act or law, in some instance, when applied in that sense, might be advantageous to the landlord. It might also be advantageous to the tenant, and vice versa. So if you don't have that agreement and the law is working against you.
Yeah, I was given a quit notice and I tried to do an out-of-court settlement, but it didn't work. I signed a document that empowered them to enact that action on me, because in trust, I told them, okay, let's settle out of this. If I'm unable to make these instrumental payments at this number of months, you are free to repossess the house. So along the line, my business had a very serious crash. So I couldn't I made some payments, but I couldn't continue the payment. So that triggered so he wasn't illegal on his part.
When you have a tenancy agreement, like what we call pacta sunt servanda, an agreement is always binding. Now, it regulates your landlord-tenancy relationship. So whatever you agree in your tenancy agreement is exclusive of what is contained in the Landlords and Tenants law or act. So for instance, you can agree to any length of notice. You can say, okay, if the landlord doesn't want you to stay again in his property, he should give you 3 months notice. Do you understand? In your tenancy agreement. But in the absence of a tenancy agreement, assuming it's a yearly tenant, you understand, what the law prescribes is 6 months. So if you don't have that tenancy agreement, that means you're going to abide by what landlord and tenancy law says, which is 6 months. But if you have it, then it's a contract between you and the tenant. So you have your 3 months tenancy quit notice or notice to quit in the event that you don't want the tenant to continue to stay in the property, and vice versa. So most people will opt for having a tenancy agreement because it gives them flexibility.
They increase rents arbitrarily too at any time they want, and if you don't want, you can leave. And that three months grace too for a yearly tenant, they don't even agree for that. So we are just living at the mercy of landlords here.
The law, first and foremost, is logical, and most times, most issues of law is tested on what we call the reasonable man's test. So, for instance, you have a landlord. Every year he's increasing rent. Every year he's increasing rent. Is a ground to go to court for a tenant. You can't be increasing rent every year. You understand? And for you to increase that rent, something must have led to it. For instance, if there had been a substantial value addition in the property. Take for instance, you rent a property, and when you rented the property, it was just a normal property. And sometimes the landlord said, look, I want to improve the value of this property. If it was normal cemented floor, he says, oh, I want to tie it. Then if there has been substantial appreciation of the location of the property, and maybe there's an increase after a period of maybe 3 years, 4 years, 5 years, it could be termed as reasonable, depending on what additions, what value, and all that. And of course, what the economy is saying. Take for instance now, if you are paying a landlord 500,000 2020, 500,000 2020, and 500,000 2022, it's not the same. So if that, because the landlord also, don't forget that the landlord's premises is also for his sustenance and survival. Possibly that is where he makes his ends meet from. It's the same market that is inflated that you go to, that he goes to. So it's the same fuel that you were buying at how much then that is now buying at. So this money you're paying him is also going to be meeting those needs. So where these things have gone up, it is also reasonable and expected that he will want to say, oh, let me hike it up. But of course, the level of hiking it up is also contestable. Some landlords come and they hike up their rent from 0 to 100. It is contestable. You understand? So you can't just say you're paying 500,000 and all of a sudden shoot it down to 1.5 million.